Hi friend, welcome to the company law update. National Financial Reporting Authority issued circular on the 26th June 2023 on a statutory auditor responsibilities in relation to fraud in a company. Dear friend, there is some certain sections in the Companies Act and apart from CARO and standard on auditing that require reporting responsibility on the auditor that should report the matter related to the fraud in a company. Dear friend, in this circular, this is noticed that in the course of the discharge of a statutory auditors are not fulfilling their statutory responsibility relating to reporting of fraud as mandated under the Companies Act rules and applicable standard on the auditing. The Companies Act and CARO and the standard on auditing places a mandatory reporting obligation on auditors to report fraud or suspected fraud to the central government and the board or audit committee. And section 143 subsection 12 of the Companies Act and related rules places certain reporting obligation on the auditor in relation to the fraud. This is overriding effect of this subsection, that is the notwithstanding anything contained in this section. If an auditor of a company in the course of the performance of his duties as auditor has reason to believe that an offense of fraud involving such amount or amount as may be prescribed is being or has been committed in the company by its officer or employees, the auditor shall report the matter to the central government within prescribed time in prescribed manner as may prescribe. And under Rule 13, this is the prescribed manner time period is prescribed here. That is the details steps that need to be followed by the auditor if he has reason to believe that an offense of fraud which involves or expected to involve individually an amount of rupees 1 crore or above is being or has been committed against the company by its officer or employees. The auditor is required to report the matter to the board or the audit committee and the central government in the form of a statement as specified in Form ADT 4. Further, clause 11 of Companies Auditor Reports Order 2020, it's also required auditor to make a statement relating to the reporting of fraud in her report. And section 140 subsection 5 of the Companies Act contains consequences for auditor if they have acted directly or indirectly in a fraudulent manner or abetted or colluded in any fraud by or in relation to the company or its director or officers. Under this section, the auditor shall also be liable for action under section 447 of the Companies Act, apart from removal and debarment for a period of the 5 years. In this regard, it is pertinent to note that the definition of fraud under section 447 of the Companies Act is abide, and it states that fraud in relation to affairs of the company or anybody corporate includes any act, omission, concealment of any facts or abuse of position committed by any person or any other person with the connivance in any manner with intent to deceive or gain undue advantage from or to injure the interest of the company or shareholder or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. For the standard on auditing 240, the auditor responsibility relating to fraud in an audit of financial statements. It deals with the auditor responsibility relating to the fraud in an audit of a financial statements. It requires the auditor to maintain professional skepticism throughout the audit, and it states that in accordance with this standard on auditing 200, the auditor shall maintain professional skepticism throughout the audit, recognizing the possibility that a material misstatement due to fraud could exist, notwithstanding the auditor's past experience of the honesty and integrity of the entity management and those charged with the governance. Para A59 to A66 of the SA 240, it details communication to management, those charged with the governance and regulatory and enforcement authorities regarding reporting of the fraud or suspected fraud. Further circular says there is a misconception against some auditor that resigning from an audit engagement absolves them of their reporting obligation relating to the fraud and consequences under Companies Act. For non-reporting of the fraud, in this regard, Honorable Supreme Court in the recent judgment dated 3rd May 2023 in Union of India and another versus Deloitte Haskins and Sells LLP, it has held that consequences of Section 140 subsection 5 of the Companies Act will be applicable also on those auditors who resign from their audit engagement without reporting fraud or suspected fraud. Court observed that, therefore, on true interpretation, even on the resignation by an auditor of a company, even during the inquiry proceeding under Section 140 subsection 5 or even prior to that, there shall not be any termination of the proceeding under Section 140 subsection 5 as observed and held by the High Court. At the cost of the repetition, it is observed that in a given case, an auditor who in fact has directly or indirectly acted in a fraudulent manner to avoid any further consequences under the second provisos to Section 140 subsection 5, resigned to avoid any consequence, and the second proviso to Section 140 subsection 5, it cannot be permitted. Acting in a fraudulent manner, directly or indirectly, by an auditor is very serious misconduct, and therefore the necessary consequences of indulging into such fraudulent acts shall follow. In view of the foregoing provision of the Act and relevant rules and standards relating to reporting of fraud and its consequences are reiterated, a statutory auditor are under mandatory obligation to report the fraud or suspected fraud if they observe suspicious activities, transaction or operating circumstances in a company that indicates reason to believe that an offense of fraud is being or has been committed against the company by its officer or employees. In such an event, the statutory auditor shall initiate the steps prescribed under Rule 13 of the Companies Audit and Auditors Rule 2014, which begins with the reporting the matter to the Board Audit Committee within 2 days of his or her knowledge of the fraud. In the case of reporting of a fraud involving or expected to involve individually an amount of rupees 1 crore or above, the statutory auditor fails to get any reply or observation from the board and audit committee within 45 days. The auditor shall forward a report in the specified form in ADT 4 to Secretary, Ministry of Corporate Affairs, Government of India. The statutory auditor is duty bound to submit Form ADT 4 to the central government under Section 143, even subsection 12. Even in such cases where the statutory auditor is not the first person to identify the fraud or suspected fraud. Resignation does not absolve the auditor of his responsibility to report suspected fraud or fraud as mandated by the law. The statutory auditor shall exercise his or her own professional skepticism while evaluating fraud and need not to be influenced by legal opinion provided by the company or its management. This issue was with the approval of the executive body NFRA. Thank you so much for watching this circular. You get copy from the NFRA site. Thank you.